Our next case is Kircher versus Boyne. Good afternoon. This is a 15-minute mini oral argument on the application. You both have 2 minutes for a free fire zone, which you may waive. And Mr. Brooks, if you would like to reserve time for rebuttal, we ask that you keep track of your time, and you may begin when you're ready. Thank you.
Good afternoon, Your Honors. Ken Brooks, along with co-counsel Andrew Abood, appearing on behalf of the defendants' appellants. We would like to reserve 5 minutes for rebuttal, and we do waive. In this court's April 12, 2024 order, it asked the parties and other interested persons to address 3 questions. I'd like to begin by discussing where the parties appear to agree on those questions and then talk about where they do not agree. As the court knows, the business law section of the State Bar of Michigan has submitted an amicus which agrees with appellants' positions on each of the questions presented. The first question was directed to the application and scope of the implied covenant of good faith and fair dealing. The parties appear to agree that the implied covenant of good faith and fair dealing plays a limited role in Michigan contract law. Consistent with the holding in Gorman, the parties agree that the implied covenant is not an independent duty, but rather only applies to certain express contractual obligations of a party. And consistent with the holdings in Burkhart and Farrell and Harp and Sims, among other cases, the parties also appear to agree that the implied covenant applies only to a contractual obligation that makes the manner of a party's performance a matter of its sole discretion. Simply put, in Michigan, the implied covenant is the legal standard by which performance of an express contractual duty solely within the discretion of one of the parties is measured. Neither side is advocating for this court to change Michigan's historical application or scope of the implied covenant. In that regard, the parties appear to also agree that the ninth...
You seem to focus on sole discretion. That seems like a narrow rule. Why wouldn't we allow it if there was discretion on both sides?
Because the state of the law in Michigan now is that it is when it's within the sole discretion. If it's within the discretion of both parties, for example, to amend an agreement, the parties could never... if you had sole discretion on both sides, how would you measure whether or not one party acted in good faith or didn't? In this regard, the parties appear to also agree that the Ninth Circuit decision in Valine is a bridge too far. And our supplemental brief fully addresses the fact that Valine and the case it relied upon, the Scheck case out of Florida, has been widely criticized by other courts and may not even be the existing law in California today. So that brings us to the second question that this court posed, and that is whether the plaintiff stated a valid claim for breach of contract based on defendants entering into the 2018 real estate transaction that added to the debt of defendant Boyne USA. The parties agree, or appear to agree at least, that in answering that question, no, the Court of Appeals properly applied Michigan law. And in rejecting plaintiff's claim below, the Court of Appeals said 2 important things about the 2014 settlement agreement. It said that it places no restrictions or limitations on Boyne's ability to take on debt. And it said that it contains no corresponding contract term to which the implied covenant of good faith and fair dealing would apply. The plaintiff appears to agree with our request that this court affirm the Court of Appeals holding on that question. Rather than
You're-
challenge,
You're saying that because it wasn't appealed?
pardon me?
You're saying that because that issue was not appealed?
Yeah, that
you're
there is
making-
not, that the plaintiff did not state a cause of action under that question. And the Court of Appeals made that holding. I think it's actually in a footnote to the opinion on, I think, page 5 of the opinion. In rejecting the plaintiff's claim below that it did state a cause of action, like I said, the court applied the Michigan law properly and looked at the terms of the agreement, so there's nothing here that would imply an obligation with respect to debt. And rather than challenge the Court of Appeals holding on this issue, plaintiff makes what appears to be a veiled attempt to argue around the holding by now claiming that the 2018 transaction and the corresponding debt was the cause of the breach, not the actual breach itself. This argument appears, at least to us, to be sophistry, and it should be rejected. The plaintiff's right to an annual redemption under the 2014 settlement agreement was subject to the terms of that agreement. That agreement contained many conditions to plaintiff's ability to redeem shares, some within her control, some not. But she was never denied a redemption to which she was entitled. In fact, as a result of the April 2019 supplemental agreement, she received the 2015 through 2019 redemptions to which she was not entitled. So this brings us to the final question on which the parties clearly disagree and where the Court of Appeals clearly misapplied Michigan law with respect to the implied covenant. And the third question this court posed is whether the plaintiff stated a valid claim for breach of contract based on defendant's refusal to negotiate an alternative formula to calculate the redemption price of the plaintiff's shares. Now this question presupposes that the defendant actually did refuse to negotiate an alternative formula, and that's not the case here. And in fact, plaintiff in her complaint doesn't specifically allege that she even made an alternative proposal and that the defendants denied it in bad faith. So I think that's important to keep in mind. What she does allege in paragraph 87 of her complaint, which is critical, is that the phrase, quote, unless otherwise agreed to by the parties, end quote, in section 2B of the 2014 settlement agreement, quote, permits, end quote, the parties to agree to an alternative method to calculate the redemption price, and that defendants refused to utilize an alternative method. Plaintiff's complaint does not, and it cannot allege that section 2B creates a duty or imposes an obligation on the party or defendants to renegotiate or agree to an alternative formula. By plaintiff's own acknowledgement in her complaint, quote, unless otherwise agreed by the parties, end quote, is permissive, not obligatory language. Without an express duty, there can be no breach. Moreover, plaintiff's complaint does not and cannot allege that section 2B confers sole or unilateral discretion on any party. Plaintiff's complaint does not even specifically allege, as I said, that plaintiff ever proposed an alternative formula that was rejected by the defendants in bad faith. Simply put, section B of the May 2014 agreement doesn't create or impose an obligation to renegotiate an alternative formula, and it clearly does not confer on the defendants any right or ability to unilaterally adjust or modify that formula. As a result of that, the covenant of good faith and fair dealing doesn't apply, and I think that goes to your question, Justice Clement. So the covenant wouldn't even have application under the terms of the agreement with respect to that claim. The contract terms here are materially different than those in Vilene, where the contract gave the franchisee the express right to extend the contract term. That doesn't exist here. And all they had to do was give proper notice, and they had the right to extend the term. It went on to obligate the parties to negotiate the terms and conditions of the extension within 60 days. So unlike Vilene, this case does not express a right to extend or express a right to amend the agreement. It doesn't create an obligation of the parties to negotiate that. It simply is permissive, not obligatory. So the Court of Appeals findings here that plaintiff has stated a cause of action because the phrase, unless otherwise agreed by the parties, created a duty to, quote, consider an alternative method, end quote. Those are the words of the Court of Appeals. And conferred discretion on defendants to agree to an alternative method misapplies Michigan law and should be reversed. Reaching an agreement is never within a performing party's sole discretion. And there are a number of Michigan cases that say that the covenant applies to situations where the performing party's performance is within its sole discretion. The Court of Appeals decision not only misapplies Michigan law, but it's also contrary to Michigan law in that it changes the express terms of the 2014 settlement agreement. Under the express terms of that agreement, if plaintiff did not like the annual redemption share price in any given year, she had the right not to exercise a redemption in that year. It's expressly stated. She had a period of 30 days within which to decide whether to take that redemption based upon that price or not. Now, under the Court of Appeals decision, if the plaintiff didn't like the annual redemption share price in any given year, she could simply demand that an alternative formula be used, and Boyne would be obligated to agree, or at least, as the Court of Appeals put it, consider a different method. In other words, the Court of Appeals holdings reads rights into that agreement that are inconsistent with its express terms. And in McDonald, this court said courts
just for
cannot
clarification,
do that.
Prior to the Court of Appeals decision, you're indicating that Ms. Kirchner could have, in 2019, could have said, I'm not exercising my right. I'm going to hold off because it's negative.
Well, she could not because she didn't qualify for a redemption under the agreement.
In 2018, she could have said that.
She didn't qualify in 2018 either. She never qualified for a redemption after 2015. She had not complied with the terms of the contract that would have given her the ability to exercise. And that's why I emphasize the fact that there were a number of conditions. She makes it sound as if she had an absolute right into perpetuity to take a redemption. That's just not, it's just not true. And she even, I think in the complaint herself, alleges that there were years when that the court found that she didn't have the right to take a redemption. But it's clear that between 2015 and 2019, when the April agreement was entered into, that she had no right to take a redemption during any of those years. The negotiations resulted in a new agreement, a modified agreement, that allowed her those redemptions. But prior to that...
In 15 through... Or
19.
14, through 19.
Yes.
Okay, it was the modification.
Yes, the April 2019 agreement was a supplemental agreement that incorporated the 2014 settlement agreement. And then it was subsequently amended again in September. But to be clear, up until to the point that that agreement was signed, between 2015 and 2019, the plaintiff did not qualify for a redemption because she didn't meet the terms and conditions of the agreement.
That's your 2-minute mark.
All right. I just want to mention that in Burkhardt, the Court of Appeals stated the judiciary may not rewrite contracts on the basis of discerned, quote, reasonable expectations of the parties. And the courts are to enforce the agreement as written. The Court of Appeals decision on this question violated those principles. So we respectfully request that the court reverse the Court of Appeals holding on this question and remand for entry of an order dismissing count 1 of plaintiff's complaint. Thank you.
Good afternoon. Joseph Ahern appearing on behalf of the appellee in this case, Kathryn Kircher. We're asking that the Supreme Court deny the application for leave to appeal in this case. We think this is a fairly straightforward breach of contract claim. Paragraph 2 of the 2014 settlement agreement, which is the contract in question here, states, quote, "Plaintiff shall have the right to redeem plaintiff shares in Boyne, USA," end of quote. Paragraph 14 of our complaint cites this very same language. Again, plaintiff shall have the right to redeem plaintiff shares in Boyne, USA. And the complaint also specifically pleads that the defendants breached this right to redeem shares. Paragraph 83 of the complaint states that the defendants, quote, "effectively took away Kathryn Kircher's rights under the 2014 settlement agreement to redeem shares." So therefore, the complaint has properly pled, number one, the express contract right, and two, the breach of that contract right. Now, as the court pointed out, there's three questions that you asked us to answer. I don't think we have to spend a lot of time on the Boyne versus Gorman. The court asked us if we should continue to follow the Gorman, which is the Michigan Court of Appeals case, or adopt the California Boyne case. As our supplemental brief indicated, we don't think that we have to abandon the Gorman standard and adopt the reasoning of the Boyne case. And we asked the Supreme Court to also adopt that as well. The Court of Appeals used the Gorman standard. Under the Gorman standard, I think Kathryn Kircher has clearly pled a valid breach of contract.
Can you give me the exact language in the settlement agreement that creates a duty to consider an alternate redemption formula?
The duty to consider an alternate,
Yeah, where's that coming from?
I'm sorry?
Where's that coming from in the settlement agreement?
That is, I don't know if that's in the actual settlement agreement, Justice. So,
Where's the breach then?
well, we're talking about the breach. First of all, the breach, we think the contract right here, the focus has been on the debt. There's two focuses, the debt and the refusal to renegotiate. The breach of the contract, the right that she had was to redeem her shares. That's number one, all right? What happened in this case is Boyne took on $300 million in additional debt. That
Let
300
me go back to you. The right to redeem, isn't, as I read the agreement, there's a share price that's set forth, starting in, 15 and 16 and 17 and 18, but not for 19.
Are you looking at the 2019 settlement agreement?
I'm looking, I think of the 14 agreement. Which one says to be determined for 19?
That's the 2019 settlement agreement.
Okay.
We're not discussing that here today. There's the 2014 settlement agreement, which we're discussing today. That's in the case, the 2020 lawsuit. There's a separate matter that's working its way through the courts. In fact, we have final arguments on that. On the order for relief under 6.12 on the 2019 case. That case, again, is we had 26 days of trial. We're going to have oral arguments in January 14th and finish that up. You're probably going to get that case some way eventually in this, depending on what happens. The only thing that's left in this case, because all the other matters with 2019 is handled under the 6.12. The court in this 2020 case said all the relief you're requesting here, except for this breach of contract, you get over here. So I'm going to dismiss those other 4 counts because we're going to address those in the 6.12 motion. What was not addressed is when they took away her shares and all that, what was not addressed in the 2019 settlement agreement was the 2014 agreement that allowed her to redeem her shares. So in other words, if we get her shares back, I think we will, in the other case that we have oral arguments on January 14th, well, do we have a right to redeem anymore? That's the issue before you. So the issue before you right now is what happened that stopped Kathryn from having a right to redeem those shares? The debt of the company went up
15,000 shares?
I'm sorry?
Just because we're getting bits and pieces of this story. The 15,000 shares?
Yeah, about 15,642 shares, yes.
How many did she start with?
I think she had about 17,000.
Okay.
The other shares were redeemed, I think in 2013 and 14. I think there was 2,000 shares that were redeemed pursuant to the settlement agreement in 2019. So what we're talking about here are remaining shares, again, approximately 15,000 shares. Does she have a right to redeem that? The defendants are saying, no, she doesn't have a right to redeem because we've got this debt now in the company. The strike price that was $773 positive in 2018, because we took on this debt, the strike price became negative $1,729. What happened? They took on the debt. Is that, and the argument there in the argument in the lower court is, well, that's okay. There is no debt requirement in the 2014 settlement or agreement, the contract. So how can that be a breach? That's what the Court of Appeals said. That's what the defendants are arguing. What happened here is the debt was taken on, destroyed the formula, and because the formula was negative, her right to redeem shares were taken away. You can't redeem shares at a negative strike price. It just can't be done. The only way to do that is you give her money and additional shares, which is an impossible situation.
Wasn't your client aware of the $300 million in debt that was taken on?
No, we were not given financial information throughout this case. The settlement agreement was in April of 2019. The financial statements, even though the defendants had them, now we're getting into facts in the other case, was not released to us till sometime later in the year.
Later in what year? I'm looking at transcripts from the hearing.
The first time we found out that the strike price was negative and our shares were redeemed was in the appellate court case on their brief that they disclosed to the appellate court in 2020 that we've taken all our shares. The appeal was for a call right. Let's get a little complicated in this. A call right, and they said, well, yeah, this call right, we still want it, but we've already taken all our shares pursuant to this settlement agreement and this negative strike price. It was the first time we found out about it, 9 months later.
But you knew, correct, that the strike price was being determined by a formula that incorporated the amount of debt.
We knew it was up.
You knew that the agreement didn't have any provision that specifically restricted Boyne's ability to take on debt.
Correct.
Right? You knew whatever strike price I'm getting is based on this formula, and that incorporates debt, and there's nothing saying that it could go up, it could go down. I mean, you could take the risk. Their debt could go down, their debt could go up. There's nothing prohibiting it one way or the other, but you knew it was going to be determined at least in part by debt.
Yeah, the formula itself has a component for debt. You take a multiple times EBITDA, earnings before interest, taxes, depreciation, and then you subtract the debt. In 2018, I think the debt was $113 million. You know, after you took the EBITDA, you get this positive number. That's where you get the $773.
Why sign the 2019 settlement agreement before seeing the financials?
I'm sorry?
Why sign the 2019 settlement agreement before seeing the financials?
Well, that's the
You
issue.
sign the 2019 settlement agreement, you agree to a formula,
Yes?
and you don't see the financials, and then when the debt comes in, you say foul.
Yeah, well, that's the issue before the trial court right now. That's a separate issue from where we're talking today. Today, we're only talking about the breach of the 2014 settlement agreement, not the 2019 settlement agreement. That's all we're talking about today.
If you were recognizing the issue isn't before us, what is the remedy you're requesting in the case that is pending in the trial court?
The remedy in the trial court is twofold. One, you can't redeem shares at a negative strike price.
Okay, sorry.
I'm sorry.
Yeah.
I'm sorry to walk around that. You can't redeem shares at a negative strike price, and they did redeem shares using the negative strike price. The agreement in 2019 said you can redeem up to $150,000 worth of stock. They said, well, great. The strike price is negative $17.29, so that means we can take an infinite amount of stock because it's a negative strike price, but you have $15,642, that'll do. We'll take it. They did that without telling us. That's just an improper, quite frankly, application of the strike price, number one. Number two, if the court finds that, no, that's okay, you can have a negative strike price, then in that case, we'd ask that it be overturned for misrepresentations made to us in the lower court, or in the facts going up to the lower court. There's other issues there with, the 2019 settlement agreement and whatnot, but that's the actual relief we're asking for.
Okay, so help me understand what we find today, how it could impact. You're saying we're here just to determine about how the redemption happened?
No, what you're here today is...
Because I know we're talking about the good faith and covenant of good
Correct.
faith and fair dealing. I'm trying to figure out what is left of this lawsuit if we agree with your position?
If you agree with our position, when we get back our shares, we will then have this right to redeem under the 2014 settlement agreement. The 2014 settlement agreement says you can redeem shares. Now the issue is, okay, now we have this debt, which we don't know what the debt is today. We just know what it was in 2019 and what happened then. At that point, then we have the right to redeem our shares. If you say, no, you don't have the right to redeem the shares because the debt's not covered, it's not specifically in the agreement, then in that case, we'd have the shares, but we no longer have a right to redeem. So that's really the issue here. And one thing I do want to point out, it seems to be the conundrum or the question here is, well, okay, you had this right to redeem, that's fine, that's in the contract, but they didn't do anything to stop you from redeeming the shares, but they did something independent, they took on debt, and that prevented it. You know, so what is the cause here? What's the breach? What's the connection?
Is there anything preventing them from doing that?
I'm sorry?
Is there anything preventing them from doing that in the agreement?
Yes, I think, well, first of all,
Point to what in the agreement?
the agreement says you have a right to redeem shares. They took action that stopped us from that right to redeem shares.
So would you agree that they could have taken on debt enough to the point, say they reduced, under the formula, they reduced the share to 1 cent?
Correct.
That they could do?
No, they could not do that.
Well, but she could still redeem at 1%, right? If you're saying that they breached by taking on debt to the point where it made it so she could not redeem, she could redeem at one
You
cent.
can technically redeem at 1 cent on the dollar.
Why is that not good enough?
Why
I'm sorry?
is,
Why is that not good enough?
Why is that not good
why
enough?
is that a breach?
The
To bring it
breach
down
is-
to 1
and
cent?
The breach is, and you look at the Hammond case and all its progeny, it says basically the good faith and fair dealing says you will not take away, you'll do no action that'll take away the fruits or the benefits of the plaintiff's contract.
Well, but you're not. You're saying, she's saying you get to redeem strikes at this, or redeem shares at this, using this formula.
Correct.
And as long as you can redeem them, it may be to your benefit, it may be less, you have all that. I mean, I thought you're saying that you can't take it on to the point where it eliminates her ability to redeem shares. But they could bring the price of them down by
Well-
taking on debt, as long as the agreement didn't prohibit them from taking on debt.
Well, that's the arguments that defendants say, but look at it a different way. They took on debt to buy some additional ski hills and things like that. What if they decided to loan the president of the company exactly enough money to get it to 1 cent on the dollar? Hey, we're going to loan you $150 million or whatever it is. We're going to put that on the debt, and that's just an IOU from you. We're not going to have the asset as the IOU. What if they did that? That would be an intentional action that would stop the contract, but that's not listed. Now, how are we supposed to list in the contract all the things you can't do to stop us from redeeming? This is,
Okay, that's a fair example. That's not what's before us. So can we go back to what Justice Kavanaugh was asking? So if 1 cent is a problem, what is that number that would be acceptable where their action in taking on legitimate debt, not the situation that you just described, but legitimate debt, would interfere and would cause a breach?
well, in the lower court, we've got expert testimony on both sides, but the concept is the lower court is, listen, when you entered in the 2014 agreement, you had a model. You owned a few assets, you leased a bunch of other assets. None of that stuff hit the balance sheet. The minute you took the $300 million was used to buy assets that they were currently leasing. That's what turned the balance sheet upside down, because if you're leasing it, it's not an asset.
But that was just that just impacted 2019.
That happened in 2018,
Happened in 2018 and impacted your client in 2019.
made the strike price negative in 2019, and will permanently affect the strike price going forward. Now, to your point, well, what if it just happened to a penny, you know, like in your example? Well, that, again, changed the dynamics of the contract that was
So
made.
they wouldn't even be able to do that?
I'm sorry?
The price cannot go down at all? It can only go up?
No, the price can certainly go down. The
Just not
difference-
based on, not because of debt?
I'm sorry?
Just not because they take on additional debt?
Well, they're going to take on additional debt no matter what. They're a large company. The debt's not an exact fixed number. It bounced around 115 to 120, 125 million based on these things. What happened here is in 2018, they said, you know what we're going to do? We're going to change our model. We're going to take these assets we were leasing, like your house or whatever I was leasing before, I'm going to buy it. Great. On the balance sheet, it's a pretty simple transaction, right? $300 million in debt, $300 million in assets of the company. The strike price formula does not contain any add back for the assets. It's the EBITDA minus debt. So when you do that, when you change your business model, then you completely alter the strike price formula. In
Okay,
this
so
case,
we keep asking, where's that line?
that line is a factual line that's being held before the court right now. There is no hard and fast line. If you hit a penny, you hit zero, you hit $1, there is no hard and fast line. That is correct. But what happened here is the actions they did prevented us from redeeming our shares, and that's the breach of contract. And one thing I would like to point out, I know I'm past my time here,
Quickly.
but this is similar to the Burkhart case. The Burkhart case we have listed in our complaint, or I'm sorry, in our brief. I think the other places have as well. Kind of a similar situation in the Burkhart, I'm sorry, not the Burkhart case, the Sims versus Buena Vista case, which we've cited. In the Sims case, the school district was to provide life insurance for its teachers. In this particular case, the breach, they did not supply life insurance for their teachers. And the Court of Appeals held that the breach in this case was the not paying of the premium. Now, there's no mention in the contract that you have to pay a premium. It
See,
says you've
Counsel,
got.
I have a question, and this is just what I'm trying to grapple with this case. And you guys have done a fantastic job arguing it, but this is what I'm trying to garner. How do you balance the right of a shareholder to redeem their shares with the ongoing operations of a corporation? And you yourself said corporations have to take out debt. It's just a part of doing business. So what's the balancing test that we use in order to kind of come up with an equitable determination of this?
Well, the balancing test, I think, goes to the Hammond case, that your actions cannot take away the fruits of the contract, the benefits of the contract. So a trial court would have to determine, hey, were your actions, did you take away the benefits here? If you added $1 million in debt because you were going to buy something, would that do it? No. But if you change your structure and you take away the fruits of the contract that she has, then you've done it, and that's the balancing test. I think the key here is, from that, Kathryn negotiated for a right to redeem shares. There is no way you can put in a settlement agreement. Here's the 400 things you can't do.
No, but what I heard Brother Counsel say is that she was not able to redeem under the contract for years 2015 through at least 2018, maybe even 2019, when it was renegotiated.
For other
reasons.
For other reasons,
reasons.
absolutely.
And then she had the opportunity to sit down at the table and renegotiate that. And she had the ability to change and say, you've taken on this debt. But there's dispute, I think, whether or not she knew that. I have transcripts saying that she did. And she could have said, I want the assets, put back into the equation.
Well, she didn't, because she didn't have financial information. The evidence for she knew the debt was, well, there's all these newspaper articles, and one of the newspaper articles might have mentioned the debt or the financing. And there's other things, like there's a footnote in one of the financials. The bottom line is the financial information that shows the debt of the company was never shown to her, was kept from her, and without that financial information, how could she renegotiate anything? How could she know? She did not know that her strike price was underwater. So how do you go to renegotiate, hey, you guys might have done something? Again, that's an issue for the other court, for the trial court, and potentially you one day. But in this case, the issue is, did she have rights under the 2014 settlement agreement, the contract? Yes or no? What were those rights? We think, and it comes down to the decision you're going to have to make. We think the decision was she has a right to redeem shares. And if they took any action, even if it's not articulated in the contract, take any action to take away the fruits of that, that is a breach of the contract.
Okay. Thank you.
Thank you.
Minute 20.
Minute and a half.
A minute and a half? Wow, okay. There are, first of all, council has stated a number of facts that are outside the parameters of the pleadings that are simply not true. And I'll try to address as many of these as I can. But first of all, his example about making a loan to an officer, that doesn't create a debt. It's actually an asset. If you make a loan to the officer, it becomes a receivable of the company, so it wouldn't become part of the debt. So that example doesn't really make any sense. But with regard to Justice Vigliano asked a question with regard to the April 2019 settlement agreement. Plaintiff, for purposes of this case, wants to ignore that. It is attached to the complaint. It is part of the complaint. And it's important to understand that plaintiff made her redemptions for 2015 through 2019, not under the 2014 agreement, but under the 2019 supplemental agreement. So there could be, she received all of the redemptions that she was entitled to. She wasn't entitled to any after 2015, but she received under the 2014 agreement the 2013, 2014 redemptions. Then from 15 on, those redemptions were all made under the April agreement, so you can't ignore that. And that,
Just to make sure that I'm understanding what you're saying. So if the 2019 agreement had not taken place, they had not come to that agreement, his client would not have redeemed anything for 15 through 19.
she wouldn't have had, yes, she wouldn't have had any redemptions from 15 through 19.
Okay.
It was a negotiated agreement in 2019 that on which she had counsel and financial advisors. It was her decision to assume the risk as to what the 2019 share price would be. And to state that she wasn't aware of the 2000 transaction is just flat out false. She was aware of it in May of 2018, a year before she entered into the April 2019 agreement. That is undisputed. She has given testimony in court that she knew about it. Her financial advisors have testified she knew about it. With all due respect to counsel, he's gotten up in front of the trial court and said, quote, we, end quote, knew about the 2018 transaction before April of 2019. And to suggest that she didn't know that the price was negative for 2019 until January 2020 is flat out false. She received not only one, but two written notices of the negative share price in May of 2019 pursuant to the 2014 agreement. And she simply said, well, I don't remember seeing them. That's her testimony. But she doesn't dispute that she received those notices. So the counsel has admitted in their brief that the Court of Appeals decision is
So,
consistent
Counsel, I
with Michigan
just
law
have a-
with regard to taking on debt.
Oh, I'll let you finish that up, but I just have a question.
Sure.
So is the issue here that, you know, they should not have taken, I mean, I'm just trying to keep it simple, right? That's just kind of the way I try to approach these cases. So is the issue here that they should not have taken on this debt, they should not have had this new purchase, they should not have moved forward with the expansion of the company? I mean, that's what I'm confused as to like, how do I balance the need of the shareholder in this situation and the shareholder's concerns with basically just the ongoing, you know, day-to-day operations of a company where ultimately opportunities are presented to that company, and how is that company supposed to navigate through that?
Sure. The answer is in the contract. The shareholder entered into a contract with the company.
Right.
Had the shareholder been concerned about the debt, the impact of the debt on the formula, the shareholder could have negotiated limitations on the company's ability to take on that debt. They took on this debt in the ordinary course, and in fact, plaintiff has admitted it was a transaction that was beneficial to the company. Let me give you an example that happens all the time. Banks put borrowing restrictions in their loan covenants with companies. So she certainly could have, if she chose to, through her counsel, negotiated limitations on the amount of debt that the company could have taken on, which then may have had an influence on the outcome of the formula. The formula is static. The two variables are EBITDA and debt. All the parties knew that. It's similar, I'll give you an example. It's similar to what we learned in Accounting 101 or Accounting for Lawyers. There's a formula that's used that's called book value, right? It's assets minus liabilities equal shareholder equity. If the liabilities exceed the assets, you can have a negative shareholder equity. Formulas can yield a negative number. She was paid a positive number for her 2019 redemption because the agreement in 2019 mandated that the company pay her at least $150,000. So as of April of 2019, she had redeemed all of her shares under the April 2019 agreement. So there was no shares to redeem after that. And there is no, this case is, the plaintiff has asserted grievances against her family and the company for over 12 years. There is not one court that has ever said that the defendants have not complied with any contractual or other legal obligation that they've owed to plaintiff. No court has ever said that. And with regard to the motion under 2.612, we're fully confident that we're going to prevail on that too, which is the other action that counsel talks about. So I think they've conceded now in response to Justice Zara's question. There's no duty in the 2014 agreement to negotiate an alternative formula. So with regard to the two questions that are before this court with respect to the C8 motion, they've conceded both those points. And the court should enter an order remanding and directing that count 1 of the 2020 complaint be dismissed. Thank you.
Thank you. Thank you both. The case will be submitted.